In this slip and fall case, the appellant moved for summary judgment on the ground that it had no ownership interest in the parking lot where the injured plaintiff fell. The Supreme Court denied that motion on the ground that the appellant made a prima facie showing of entitlement to judgment as a matter of law, but the plaintiffs raised a triable issue of fact. The appellant then moved for leave to renew, asserting that it had not received the plaintiff's opposition papers before the determination of the motion. It submitted additional documentation supportive of its contention that it did not own the parking lot at issue and that the plaintiff's evidence suggesting otherwise was erroneous. The Supreme Court denied the motion for leave to renew on the ground that the appellant failed to offer a reasonable justification for not submitting the additional documentation with the original motion. We reverse. The appellant established its entitlement to judgment as a matter of law based upon the evidence submitted in support of the original motion, and the motion was denied only based upon evidence submitted by the plaintiffs in opposition to the motion, which the court determined raised a triable issue of fact. The appellant's non-receipt of the plaintiff's opposition papers constituted a reasonable justification for failing to rebut the plaintiff's evidence. Thus, the motion for leave to renew, which was supported by evidence showing that the evidence relied upon by the Supreme Court in denying the original motion was erroneous, should have been granted. Upon renewal, summary judgment dismissing the complaint insofar as asserted against the appellant should have been granted on the ground that it had no ownership interest in the parking lot where the injured plaintiff allegedly fell. In a class action inter alia for a judgment declaring that certain membership campground contracts are void and unenforceable as contrary to public policy, pursuant to General Business Law, Section 659, the defendants, Rank America, Inc., Resorts, USA, Inc., and Outdoor World Corporation, appeal, as limited by their notice of appeal and brief, from so much of an order of the Supreme Court, Queens County, dated January 16, 2001, has denied those branches of their motion which were for summary judgment: A, dismissing paragraphs 45B, 45E, and 45G of the third cause of action in the amended complaint insofar as asserted by the named plaintiffs against them. B, dismissing the fifth and sixth causes of action in the amended complaint insofar as asserted by the named plaintiff against them. C, dismissing the plaintiff's request for punitive damages, and D, dismissing the third cause of action in the amended complaint in its entirety insofar as asserted against the defendant, Rank America. And the plaintiffs cross appeal from so much of the same order as granted that branch of the motion of the defendants, Bank America Incorporated, Resorts USA Incorporated, and Outdoor World Corporation, which was for summary judgment dismissing the second cause of action in the amended complaint, and denied those branches of their cross motion which were for partial summary judgment and the disposition of sanctions against the defendants and their counsel. Ordered that the order as affirmed insofar as appealed from and cross-appealed from is dismissed without costs. Contrary to the contention of the defendant, Rank America Incorporated, there in and after the appellants, the Supreme Court correctly determined that there can be independent inability under the Membership Campground Act, Section 656, for violations of General Business Law, Section 349, 350, and 369. See General Business Law, Section 660, Meacham versus Outdoor World Corporation, 273, Appellate Division 2nd, 208. Member of Senator Daley's branch, Laws 1990, Chapter 488, 1980, New York Legislative Association, the appellants failed to establish their establishment to judgment as a matter of law regarding the plaintiff's claim that the contracts were unconscionable, requiring denial of that branch of the motion.
I think I got that basically perfectly.
That was a little slower.
132.
132.
What's the time that I